And the name of the game here is to recapture the lost revenue. We had one client that lost 80% of their sales in a weekend when all of the knockoffs came up. We've had other clients that once we cleared up the marketplace saw a 20% increase in sales. The largest we've seen in diverted sales is over $7 million that was sold. Imagine what something like that would do to the bottom line of your listeners and viewers.
Welcome to the E-com Breakthrough Podcast. Are you ready to unlock the full potential and growth in your business? You've already crossed 7 figures in sales, but the challenge is knowing how to take your business to the next level. Join Josh Hadley, an 8-figure e-com business owner and investor, as he interviews highly successful business owners. Get ready, because you're going to learn specific actions you can take today to help your business reach its full potential and leave a lasting impact on the world.
Welcome to the E-com Breakthrough Podcast. I'm your host, Josh Hadley, where I interview the top business leaders in e-commerce. Past guests include Kevin King, Michael E. Gerber, author of The E-Myth, and Stephen Pope of My Amazon Guy. Today, I am speaking with Stanley Ference, one of Pittsburgh's leading patent attorneys, and is a principal of Ference and Associates, an intellectual property law firm based in Pittsburgh, Pennsylvania. And today, we are going to be talking about how you can stick it to all of those online or overseas sellers that are cheating on your online listings. If they're copying you, they're counterfeiting you, they're creating derivative works based off of your products, we're going to be teaching you how to stick it to them so that they learn that if they want to compete in the U.S. marketplace, they need to abide by the U.S. laws, and they are not protected just because they live overseas. This episode is brought to you by E-com Breakthrough, where I specialize in investing in and scaling 7-figure e-commerce companies to 8 figures and beyond. If you're an ambitious e-commerce entrepreneur looking for a partner who can help take your business to the next level, my team and I bring hands-on experience, strategic insights, and the resources needed to fuel your growth. So if you or someone you know is ready to scale or looking for an investment partner, reach out to me directly at josh@ecombreakthrough.com. That's ecom with 2 M's, and let's turn your dreams into reality. But today, I am super excited to introduce you all to Stanley Ference. Stanley has an extensive background in intellectual property law, including online counterfeiting. He advises clients on all aspects of patent, trademark, and copyright law. Stanley's practice includes litigation for both plaintiff and defendant, patent prosecution for computer-related technology, trademark prosecution, and oppositions. Stanley has argued before the U.S. Court of Appeals for the Federal Circuit and has served as an expert witness. He is an e-discovery special master for the United States District Court for the Western District of Pennsylvania. Ference was also selected to the 2022 Pennsylvania Super Lawyers list. In 2020, Stanley was recognized by Best Lawyers in America, Chambers and Partners, IP Stars, and Super Lawyers. He has also been recognized as a Lawyer of the Year by U.S. News, and the firm has been recognized as a best law firm. So with that introduction, welcome to the show, Stanley.
Well, Josh, thank you very much for having me.
I am genuinely super excited to be talking to you today because you're hitting the nerve of, I think, 90% of all of the online sellers here, where they are getting their products copied or derivatives of their products are being pitched. They come out with something new, and then it's no more than 3 to 6 months, and there's counterfeits, and there's replicas, and there's duplicates, and people are already knocking them off. And I hear so often, so many sellers that are just like, well, I guess there's not a whole lot I can do. But in reality, and I've learned this lesson myself, because our business, we didn't protect our copyrights. We didn't protect our trademarks. We didn't do that for a period of 5 years. And had I protected those, I would argue our business could have been double or triple the size that it is now. But we kept letting other overseas sellers cheat and steal money and revenue from our business. So that's why I am so adamant about this, because I never did anything about it because I didn't feel like I had anything. There was no recourse for myself. You just have to let it happen. But Stanley, you're here to say it's the exact opposite. You've got options. And so, Stanley, why don't you kick things off by first, you've got some amazing examples that I want you to show to the audience of just the amount of counterfeits and things that you've seen in your experience with all the clients that you've worked with.
Okay, I'll start off with this. This is called the Rapid Slicer, and you'll note the pictures. This is the authentic product.
So Stanley, just FYI to the listeners, if you're listening to this podcast, he's showing visuals here. So come check out the YouTube recorded version of this so you could actually see the products he's showing up on the screen here.
Yeah. Well, this is the knockoff version. And as your viewers can see, the pictures are identical. The packaging looks a little different, but it's the brand owner's imagery that's all over the place. So we were able to get these knockoffs taken down. Okay, this is a product called the Orange Screw. And this is used for anchoring things into the ground. And the person behind this became very emotional about it because the listings for the knockoff products included his own pictures, pictures of his hands, pictures of his wife, pictures of his mother's dog. Right? So it's, when you are knocked off, it can be a very emotional occurrence. Okay. We also have something called the NEG, hard-boiled egg peeler, and this is the original and the knockoff, same size box, again, same imagery, and the products are identical. And we also have a dog chew toy here that acts as a toothbrush, and this brand owner found out that there was a problem with the knockoffs when somebody reached out to them telling them the dog had destroyed it and eaten it, and pieces had gotten stuck in their stomach, and wanted to know if the brand owner would pay for the vet bill for the surgery to remove the pieces. And it wasn't even the authentic product. It was a knockoff that was made using inferior product. Right? So there's all sorts of stuff out there, and you do have options when you're knocked off. The knockoffs can range from folks selling directly against you on your own ASINs and using your imagery and advertising, but not delivering your product to, going out on another ASIN. And the name of the game here is to recapture the lost revenue. We had one client that lost 80% of their sales in a weekend when all of the knockoffs came up. We've had other clients that once we cleared up the marketplace saw a 20% increase in sales. The largest we've seen in diverted sales is over $7 million that was sold. Imagine what something like that would do to the bottom line of your listeners and viewers. Okay?
Yeah.
What we try and do is clean up the problems on the online marketplaces, particularly on Amazon, and have fair competition. Now, there are any number of tools that we can use, and we've used them all. It ranges from utility patents, design patents, trademarks, copyrights, or just plain old unfair competition. And now, one of the things I want your viewers and listeners to know is that they do have options when they have a problem like this. Every client we've got has said, we're very glad we found you. We've talked to other lawyers and they told us there was nothing we can do. And it's very
well. It's Stanley. I'm going to interrupt you there just to echo that same sentiment, because I have also reached out, and over the course of the last few years, as we've been trying to create our own defensive moat around our intellectual property, I've had similar conversations with lawyers that it's like, well, you can try to submit your copyright infringement claim on the Amazon's marketplace and your brand registry console. You could also try to use the Apex program for patents, right? Design patents, you just have to submit it through your brand registry. Same thing with trademarks, etc. But if Amazon's not going to accept it, I'm sorry, you don't really have much you can do unless you want to pay $30,000, $40,000 for like a lawsuit, right? So, Stanley, I'm curious to hear your perspective on that.
Well, it's a crapshoot with what you're going to get making a complaint to Amazon or another marketplace. Okay, you're going to have somebody review it. They may or may not take it, and you're not going to get the outcome that you want. We avoid all that by going into court and getting a judge to tell the marketplace what they need to do. And from the marketplace's perspective, that gives them some cover, because they can tell their sellers, hey, we're not the ones making this decision. A judge made it, and we got to do what the judge has ordered us to do. So if you got a problem, go see the judge. Okay? And like I said, it can be very emotionally rewarding. At the conclusion of one lawsuit, when the business came back, the brand owner sent myself and my colleague white Stetsons, because we're the guys that wear the white hats.
I love it. I love that. So, Stanley, maybe walk our listeners through what are the different options that people can utilize to protect themselves, and then if they do have somebody infringing, what are the action items? Because basically you boiled it down to say, don't rely on the marketplace, because Amazon, and frankly speaking, I genuinely don't believe that Amazon wants to be the third party or the middleman in any copyright infringement claims. They don't want to be the middleman in any trademark infringement claims. They want to be out of it. And so ideally, yes, if you're coming with a court order from a judge, Amazon's like, great, we know exactly what to do in this. Whereas if you just throw it to them, be like, somebody's copying me, Amazon's like, you're just at the whim of whoever is receiving that and how they're feeling that day, right?
Amazon or another platform is not your friend. Okay? They're not there to look out for your best interest, because any platform is making money from the sales of the knockoff products. So when they take the knockoff products down, they're losing a revenue stream. Moreover, they're incurring expense to take them down. So if you think Amazon's going to help you, they're not. It costs them too much money to do that. Okay? So you've got various arrows in your quiver. And one of them is a patent. But unlike everything else, with a patent, there's a time limit. You have to file for a patent application within 1 year of the first public disclosure. And that's for the U.S. The U.S. gives a grace period. Other countries do not. Okay? But the benefit of a patent is it covers the product itself. And it's not unusual for us to see a continuum of problems. And it starts off with somebody knocking off the product and the packaging using the same name. And as you continue to push, they may rebrand it. They may no longer use the brand owner's photographs to advertise it, but they're still delivering the same product. So the patent helps on the continuum, because it protects the actual product itself. But there is the time limit. And then there are two types of patents. There's a utility patent and also a design patent. The design patent protects the ornamental features of a product, The utility patent protects the actual product itself, but they both have the 1-year limit. Then you also have a trademark. You have both a registered trademark and common law trademarks. So even if you, as you said, Josh, you waited 5 years to register your trademarks, you still have common law protection even without a registration. Okay? So all is not lost if you haven't acted to protect yourself. Copyrights, there's no time limit to get a copyright registration, and the copyright attaches from the moment the expression is set forth in a tangible medium. Now, you can't bring a lawsuit if you're a U.S. resident until you have a copyright registration. That doesn't apply to any of your listeners who are outside the U.S. under a treaty named the Berne Convention. Right? And then we've also brought cases under Section 43A of the Lanham Act, which is federal unfair competition. And an example of that would be somebody is using your photographs of your product, but not delivering your product. They're delivering their own product. Okay? So I tell clients, don't worry about trying to pigeonhole your issue into one of these categories. What you want to do is talk to a lawyer like me and explain what your problem is, and then we'll make the decision on what is the best way to resolve the problem. Right? So if you've seen a dramatic decrease in sales, you know what's going on and reach out. If you're seeing a slow decrease in sales, again, reach out. Because in this area, sort of being knocked off is a sign of success. Nobody wants to knock off somebody that's not doing well. So it's hard to swallow, but it's sort of congratulations, you're so successful, people want to knock you off.
Yeah, exactly. Well, I think the best mindset shift there is it's kind of like when you're playing a video game and at the end of each level, you have to beat a certain boss or a monster, right, in order to make it to the next level. And as you up level in business, right, you're beating different levels of the game of business. Yep. Okay. And then this is one of those beasts that you've got to conquer at the end of a level, which is great. You've hit success. Now you've got people copying you. Welcome to level 10. Okay. Now in level 10, you've got to figure out how to slay the dragon here in level 10. And then that will allow you to up level to level 11. And so I see it as more of like, that's the mindset I think people need to take, is that don't be afraid of this. Don't feel like, oh, if I just bury my head and don't do anything about it, it's going to go away. Like, you've got to face the dragon if you want to grow, if you want to scale, if you want to move on to that.
And there's all sorts of software out there that will identify for people hot selling items on Amazon and walk you through where to source it. But it's totally without regard to any intellectual property rights that the creator may have. Right? And yeah, it gets very frustrating and it's very emotional. Folks have invested, their time, effort, and money. In some cases, people are putting retirement funds into building these Amazon businesses, and somebody comes in and knocks you off and takes away the sales. And you don't have to just sit there and take it and go, woe is me. You can fight back, get them off the marketplace, and get your business back. Okay? Now, like I said, our approach is through litigation. Most people are conditioned throughout their lifetime that, lawyers are bad, lawyers are sharks, and you want to avoid litigation. But many times clients don't really have a choice. Their back is to the wall, and litigation is a viable option that's going to take care of the problem.
Yeah, I think that's an important point. Like we have been taught, like, avoid you don't want to be involved in a legal battle, right? You don't want to have to work with a lawyer. So do anything you can to not do that. But I think there is a time and place for it, certainly. So, Stanley, my question would be, maybe can you walk us through maybe some case studies that you can share that are publicly available of, different brands that you've helped out with, and what was the course of action that you took? And ideally, maybe you could go through each of these different items, right? Like a patent. How did you go about resolving a patent issue? How did you resolve a design patent to copyright issue as well as trademark?
Okay. Let's start with the copyright and the trademark. A copyright protects against copying. And actually, before I start that, let me say, there's these various arrows in your quiver that you can use, but you have to enforce them. So getting them is a start, but you should not expect just because you have them, people are going to respect them. I was chatting with one client, and given their odyssey, I was told earlier this week, their big takeaway is you need to enforce what you have. And the enforcement's up to you. You can't rely on the marketplace to do it for you. Okay, so a copyright protects against copying. It goes in, it attaches at the moment something is fixed in a tangible medium. So Josh, in your business, how do you create your visual works?
Yeah, so my wife designs every single one of our products from scratch, hand-drawn everything, illustrations, and then we will see other people that might make a tweak or two here and there, but you could definitely tell it's a derivative work. They copied 80% of our stuff, but then they maybe switched a rainbow from the top down to the bottom so that they are different.
Well, yeah, so they may be different, but they don't want to be too different, because most people, when they see a product or hear about a product, certain key aspects of the advertising stick in their mind. It may be that there's a rainbow in one of the pictures without really thinking about, is the rainbow at the top or is the rainbow at the bottom? So they're trying to design this stuff so it triggers an association with the authentic product. Okay? So your wife and your company have a copyright in those designs at the moment they are committed to paper, fixed in a tangible medium. Right? But they're not able to sue on them at that point, because in the United States, and it's different for folks who are in other countries under the Berne Convention, but for folks who are in the U.S., before you sue, you have to get a copyright registration. Okay? The copyright registration is $65. It can take a couple of months. If you want to pay some more money, an $800 expedite fee, you can literally get it overnight. Okay? And it's not necessarily one copyright registration for each work or each advertisement or each picture. If there's some common themes, you can group them together, so you don't have to spend $65 for everything. And then once you get the registration, you've got the ability to sue on the registration and go into federal court. And you also have some benefits. You're entitled to a presumption of validity, and you also have the ability to get statutory damages and attorney's fees. So with statutory damages, Congress had said you don't have to prove what your actual damages are, like a lost licensing fee or something. You can get up to $30,000 for non-willful infringement and $150,000 for willful infringement. And on the trademark side, you have common law trademarks. so you don't need to register your trademark. And a little brief history lesson here. Remember, the United States is a federal government that the power resides in the people, and the federal government only has the powers that are given to it by the Constitution. The Constitution makes reference to patents and copyrights, but nothing about trademarks. So to get a registered trademark in the United States, you have to use the mark in commerce, which Congress has the authority to regulate. Okay? But you have your common law rights, and there's no time limit for filing a trademark application. These days, with the number of Chinese applicants who are filing, it's 11 to 12 months after you file before you get your first office action. So it's going to be over a year before you get a registration if nothing goes wrong. If it goes straight through, you're at about 13, 14 months. Okay? On the patents, like I said, there's a design patent that will cover the ornamental design of a product. One of the most famous design patent cases is a Supreme Court case, Gorham versus White, with what dealt with the design of silverware. Okay? And on the utility patent side, you can get a patent that will protect against the product and also includes some method claim. Now, it takes a while to get it. You're lucky if you're going to get your first office action within 18 months. On the utility patent side, it's going to be 2 to 3 years before you get the patent issued. There are some ways to expedite it. On the design patent side, it'll be a little quicker than that, but it's not going to, it's not like the copyright where you file it and you get it. One of the little known ways to expedite the patent side is if you're 65 or older, the patent office will fast track everything for you. They're concerned that if they don't, you won't be alive by the time they get to acting on it.
Fascinating. So the hack is get older real
I'm not saying that. Enjoy your youth while you can.
Stanley, this is a great overview. Now, I would love to dive into some case studies and maybe share some real life examples of clients that you've worked with. Walk me through, like, what does that legal process look like and what ended up happening for these clients?
We'll start with the neg, which is an egg peeler. This has a very interesting history. It was designed by two ladies, one of whom wanted to take deviled eggs to a cocktail party and was having problems peeling the eggs. And it was prototyped on a 3-dimensional printer in their local library, but before they could use it, they had to be taught how to use it by an 11-year-old. And now, they, in their situation, they had several things going. The name, which was a registered trademark, was being counterfeited. Their imagery, their copyrights were being used as well, and they also have a utility patent on the product itself. So ultimately, no matter what people did in terms of the packaging and changing the imagery, they still had the patent to fall back on. And we were able to take care of the marketplaces and bring their business back to the level that it had been at, because they took a big hit. But it's never over. It continues. It continues to this day. This particular product sells very well in the fourth quarter. And so once you initially clean up the marketplace, you have to have some sort of monitoring and enforcement program in place. Okay? But you can see one of the founders for the neg will occasionally pop up in videos that are using by the knockoffs. So you can imagine the frustration and how emotionally upsetting that can be to an inventor or a brand owner to see themselves plugging the counterfeit product.
Yeah. So I have two follow-up questions for you on this topic. So number one is, can you group multiple sellers into a lawsuit? So let's say you're being knocked off. This guy's, using your trademark. This guy's, calling it a different brand name, but it's the same product, right? And it just has a different label and wrapper on it. So my question would be this: can you group multiple sellers into a lawsuit? And then number two is, I could foresee this getting really, really expensive if your only recourse is like, all right, I knocked this guy off. Now 1 week later, I've got a new guy, new Chinese brand, new address, whatever. And now I'm going to have to file a new lawsuit. Like, that's going to be overly expensive. And I think that's the reason why a lot of people just don't do anything, because they're like, this is way too expensive. How in the world can I police this? If I get somebody down with a lawsuit, that's great, but then somebody else has started up their business next week.
It all depends on the economic harm that people are incurring. Okay, we have brought lawsuits against individual sellers. We brought them against a group of half a dozen or so, up to over 400. Okay? And I say it all depends on the economic harm, because it may be that there's one seller out there that is really doing this, and we've seen situations where clients are losing between $100,000 to $200,000 a month in revenue based off of one or two sellers. So obviously in that situation, you're not so much concerned about the number of sellers. It's, what do we need to do to get those lost sales or those diverted sales back? So yes, you can group the sellers together, and the more the merrier, as it were.
Okay. And then are you just constantly like another shop pops up? Because I know with the overseas sellers, as I attend different conferences, and we had some overseas sellers that were kind of pulling back the curtain and saying like, guys, this is what you're up against. This is what all these overseas sellers are being taught, where they go through and they purchase IDs and social security numbers, etc., so that when their business goes down on one account, they go and pop open the new one. Here's my ID I already purchased. I've got thousands of IDs. This is just a whack-a-mole game at this point, because they just pop up a new Amazon shop just like that. So are you just having to file, lawsuit after lawsuit?
What happens is the word gets out that a brand owner is enforcing their rights and causing pain for the seller. And for better or worse, there are a lot of products out there on Amazon. And we find what happens is once sellers start to realize that selling a particular product is going to cause them pain, they move over to another product. All right?
So they just go to like an easier target. You're saying that the word gets around and they're like, ooh, this brand is really being defensive with their IP strategy, which they should. And so they just go to someone else that doesn't care. And you see that working more often than not. Like, it isn't this constant game of whack-a-mole. I'm sure it comes up occasionally, but do you see it like when somebody implements a defensive IP strategy, it actually cleans it up for a good period of time?
It does clean it up for a good period of time, but it's not like you're one and done. It may take several lawsuits against hundreds of sellers, and even then, and then it'll be pretty clean, but it's never going to be entirely clean because you'll have a few people that, may be late to the game or maybe trying to circle back because they've purchased and are holding on to a large amount of inventory. But it'll be nowhere near what it was.
Yeah. Okay. Makes a lot of sense. Now, my next question would be, what is the average cost to file some of these lawsuits? And maybe they're different. Maybe a trademark lawsuit is cheaper or a copyright lawsuit is cheaper versus utility patent. I'm sure there's a lot of factors that can go into this, but if you wouldn't mind maybe giving our audience maybe like a lay of the land of here's the different types of lawsuits that we file, and here's the average going rate as a ballpark, just to help people budget. And again, as you mentioned, like you've got to weigh the economic impact to your business. Like if you're only losing $1,000, right? Are you really going to go spend, I don't know, $5,000, $10,000 to file a lawsuit plus to recoup that? So Stanley, can you give us insight there?
A lot of the cost is going to depend upon the number of sellers that are out there. But we're very cognizant of the impact that this has on people. And, we want to be able to work with our clients to make it affordable for them. And so far, nobody's complained about our fees. Fear of the cost should not be a reason not to reach out to deal with your problem.
Okay. Fair enough. Stanley, can you go through, maybe there's a couple other case studies you might be able to share? I think the egg was a great example. A couple others you might be able to share with us and your clients?
We had a recent one that included review hijacking. And what I mean by that is the folks had, the sellers figured out how to create a variation on an ASIN that the sellers did not own, and were putting their product up. So whenever the client would advertise for their own, spend money to advertise their product, people would click on the advertisement, bring up the client's ASIN page. They would see embedded in there, like you're buying a different colored shirt. You're wearing a blue one, I'm wearing a white one. Well, you had the client's product, and then at a cheaper price, you had the knockoff product. Okay? And the client was very frustrated because Amazon wouldn't do anything with that. Well, what happens there is the knockoff product now all of a sudden has access to all of the client's reviews. So this product that had been up for 2 days had, over 10,000 reviews, none of which were for the product. They're for the client's product. So we were able to include that in a lawsuit and point out to the judge that that's unfair competition. You can't be using reviews for something other than your own product to promote the product. And we're successful in having the judge enter an order that directed Amazon to take down the competitor's product. And
love that.
I'm sure you've seen issues in your own business with reviews. Okay.
Yeah.
In that particular case, they were sort of piggybacking off of the client's reviews, but sellers will also cycle through products through ASINs. So it may be that a good segment of the reviews talk about features of the product that are no longer in the product because it's a different product under the ASIN. Again, that's not permitted by Amazon's policies, but people do it anyway.
So are you able to go after these? I love this conversation where these are kind of more different, like these are fringe scenarios, right? These are different than copyright infringement and trademark, but I'm loving this. Like, what other kind of like fringe scenarios have you dealt with? Just like these reviews, what else are you seeing that you filed lawsuits for to get resolved?
These haven't involved bringing lawsuits. These have involved helping the brand owners, where client got a copyright on a particular product. The product was noted by some Chinese sellers, and they filed a design patent in Europe, the UK, and the United States, and then used the US design patent as the basis to complain to Amazon and take down the original creator's listings. And so one of the things we're able to do there is file a request for reexamination with the U.S. Patent Office to invalidate the design patent that was being asserted against our clients on our client's product. I thought that was pretty creative on behalf of the Chinese sellers.
Yeah. And that's what's insane is just like, if you just played by the rules to begin with, like why don't you put the same amount of time and energy to be creative with trying to cheat the system than you are just trying to come up with a better product, right?
Well, I think one of the reasons for that is the market that they get access to through Amazon and the amount of money that can be made.
Yeah.
And, I spoke earlier about the diverted sales. The largest number we've seen is over 7 million in diverted sales. But we've also seen 900,000, a million. And typically it turns out that, say 20% of the sellers account for 80% of the sales by volume. Right? So, just knocking off a few of the counterfeit sellers can greatly increase the bottom line of the U.S. seller.
Yeah.
Okay, because that's what this all comes down to. How can your listeners and viewers increase their sales, and are they losing sales to the knockoffs and the counterfeits?
Stanley, this has been a great episode. I think this has been very informational, not only for myself, but I hope for our listeners as well. And understanding what rights they have and understanding that they can actually do something. Before we wrap things up, I want you to talk real quick about kind of the last scenario that doesn't apply to the patent or design patent, utility patent or copyright or trademark, was this kind of like unfair competition act or something. Can you elaborate a little bit further on that and how we might be able to use that as a defensive strategy?
Okay. So the Lanham Act is it's the Trademark Act. It's named after, I believe, Senator Lanham, who was the proponent of it. But it covers infringement of a registered trademark, counterfeiting of a registered trademark, and also unfair competition. Who knows what unfair competition is, right? It's not statutorily defined. And so there's a lot of room in there for the courts to create their own definitions of unfair competition. It's sort of like Potter Stewart's definition of pornography. I know it when I see it. All right. So what we've been able to do is, for example, the review hijacking. That's unfair competition. So that violates the Lanham Act, Section 43A, and is a basis for the court to order it to stop. Now, we've also used it when somebody is lifting your images and you don't have copyrights on them, the images, and then using those images to advertise a product that's not yours. One of the very first cases that was brought under the Lanham Act was here in the Third Circuit in Philadelphia, and it involved a situation for dresses. And there was a company that was doing very well with its dress. The defendant knocked off the dress, poor quality dress, but was using the company's advertisements, but they weren't delivering the same dress. So there's a long history of case law that says you can't use either somebody else's photographs to sell your product, and you can't use photographs of another product to sell your product. You got to be truthful. Right?
Yep.
So where who knows where these folks get the advertising materials that they use, but oftentimes they lift them from the brand owner's own materials.
Yeah.
Be it they're just reusing your Amazon listing materials, to they're scraping stuff off of the brand owner's website. If somebody's gone through Kickstarter or Indiegogo or one of the other early stage sites, people may lift the materials from there.
Yeah.
Okay? So, the unfair competition is pretty flexible. And if we are able to convince a judge or show a judge that what the defendants are doing is improper, that provides the unfair competition provides a basis for the judge to do something about it.
Love that. And Stanley, when you get a judge order, does Amazon freeze that person's assets so that they can't just take out all their money and go lock things up and be like, yeah, good luck trying to catch me?
Yes, our orders include an asset freeze provision.
And that's where I think that's where the teeth really sinks in. I know the game with these overseas sellers, they think they can't be touched. And so when you slap a lawsuit on them and get a judgment by a judge that then forces Amazon to freeze the distribution out of their Amazon account, if they have $500,000 sitting in that account, they can't take that money out. And so whatever, judgment comes from the judge and whatever money may be coming to you or not, that teaches a real valuable lesson to those overseas sellers. And that's where I think a lot of them, their eyes start opening up. And like you said, word starts getting around, like, don't go after them because they took all of my money. Right.
Right. It creates a pain point. And that pain point is not there if you make a request through Amazon to have something taken down.
Yeah, it goes down, no financial impact, maybe a little bit. They got to figure it out, create a new ASIN, whatever. But it's just, it's barely a slap on the wrist, right?
There's no ouch there.
Yep.
Right. And with our litigation approach, there's an ouch there. Word gets out. And they move on to other products where there is no ouch.
Yeah.
Right? And, unfortunately, there are a lot of products out there that they can knock off.
But Stanley, as we wrap things up, I love to leave the audience with 3 actionable takeaways for every episode. So here are the 3 actionable takeaways that I noted. You let me know if I'm missing something here. Number 1 is enforcement of your IP is up to you.
Yes.
And I think this is the biggest misconception. There's a lot of people that will go out and preach and sell you on the fact that you need to have design patents, utility patents, trademarks, and copyrights. Now that's true. You should have those. But guess what? If that's the only service they provide you is like, here you go, we sold you these things. Good luck trying to figure out how to defend them. That's where I think most people are stuck. And so, yes, it's great that you have those assets, but it is your responsibility to figure out a defensive strategy to actually protect your IP. And you need to go on the offense. You need to find those people that are infringing and then take the appropriate action. So that's number 1, is enforce your IP rights. And I promise you, if everybody listening to this episode and everybody in the e-commerce space actually enforced their rights, guess what would happen? The overseas sellers would stop cheating if everybody enforced their rights. But because not everybody enforces their rights, they continue to cheat because it's a quick buck that they can make, as you laid out.
Right.
So action item number 2 is you need to actually obtain IP if you don't have IP. So if, as you listen to this, you're like, oh, I don't have some of these things, trademark, copyright, utility patent, design patent, like you can go get them, and it's a good proactive measure. But I think finally, like the third and final action item is, even if you don't have those things, you don't have a utility patent, maybe that year is already passed, you still have a trademark, even if you haven't filed that trademark. You still have a copyright, even if you haven't filed that copyright. So my final recommendation is, if somebody is creating a counterfeit, they're cheating, they created a duplicate or a similar listing or a similar product to yours, it's a derivative off of your work, go after them. And it's not go blindly after them, it's hire an expert. And Stanley, I think you're the go-to person because you shared more kind of like actionable legal strategies and ways to defend yourself than I've ever heard from somebody else. And so the approach that you make, and so many people are sitting on their hands, they don't want to get into a legal battle, and so they just put their head in the sand. But I promise you, if you're prepared, you will not fear. And so if you have somebody like a Stanley in your back pocket, you know that, okay, if this does happen, I don't have to figure it out myself. I have an expert that has seen hundreds of different crazy cases and other violations and things that he's seen on Amazon. Go to an expert. They can provide insight and figure out an actual defensive strategy for you.
Right. What the potential client needs to do, what the seller needs to do, is identify that they've got a problem. They don't need to figure out the solution to the problem. That's what we're here for.
Love that. Awesome. Stanley, as we wrap it up, I ask each guest the following 3 questions. So here we go. Number 1, what's been the most influential book that you've read and why?
Ever since I've been a little kid, I wanted to be a lawyer. And I used to read books in my parents' basement. One of them was by Louis Nizer, and it was My Life in Court. And what I got out of that book is the lawyer's role is not to tell a judge what they can do. It's to tell the judge why they should do it. And acting as an advocate. And I think that's really what lawyering is all about.
Love that. That's the first book recommendation of its kind from a legal standpoint on this podcast. Question number 2, what is your favorite AI tool or software tool that you've been using?
I'm going to go with just sort of the generic Outlook. It's just very hard to manage a calendar and all of the emails, and Outlook helps do that.
Easy enough. Keeps you organized.
Yep.
All right. Final question. Who is somebody that you admire or respect the most in the e-commerce space that other people should be following, and why?
Well, I'm going to broaden that out a little bit into the tech space. This is probably one of the few times you'll hear these 3 people mentioned together, but Bill Gates, Steve Jobs, and Steve Wozniak. Because what they did is they came up with an idea. The Wozniak and Jobs started off in parents' garage and built up these huge companies. Right? So, they had a great idea and were able to grow it and scale it, and look where their companies are today.
Great sources of inspiration, that's for sure. Stanley, this has been great. If people want to reach out to you, they want to learn more about your services, your offerings, where can they reach out to you at?
You can check out our websites. Our practice area website for this is onlinecounterfeiting.com, a memorable domain name. And our firm website is ferencelaw.com, FERENCELAW.com. You can also reach out to me by email at sdference@ferencelaw.com. And again, Ference is FERENCE like conference or reference.
Excellent. Stanley, thanks so much for taking time out of your schedule to join us on the show today.
Thank you, Josh.
Thank you for listening. Visit ecombreakthrough.com for more information. If you've enjoyed today's episode, the best way you can show your appreciation is by clicking the subscribe button and quickly leaving a review. See you again next time.